Are you gonna be quiet?
Well, he trying to get me life. He don't have no evidence, sir. Man, shut up talking to me because you trying to get me life, man.
Okay.
And he's asking for $250,000 bond. What's wrong with him, man? You ain't got no evidence. Of course I'll be emotional, man.
Okay, the court's gonna change the bond to $500,000.
He don't have no evidence. Now it's $500,000. Make it $1 million. It don't matter. I can't post $250,000.
Okay, I'll make it $1 million then.
I can't post none of it anyway.
Okay, Your Honor, so the final amount for the bond?
$1 million.
This reckless young man is in court today facing more than 7 serious charges, none of them minor. If convicted, he's staring at a potential life sentence. From the moment the hearing begins, the entire scene is chaotic. At one point, he even squares up to an officer as if this were some street fight instead of a courtroom. His behavior throughout is shocking. No respect for the judge, the jury, or anyone else in the room. It's almost unbelievable that someone could cause this much trouble before even reaching trial. And the judge's reaction at the end? Absolutely priceless. The whole situation raises a serious question. Does this guy deserve another chance on the streets? Or is prison the only safe option? Let's break down the events and see exactly what went down inside that courtroom.
All right, where is Mr. McDowell?
He's right here, Your Honor.
Okay. All right. Officer, are you going to be conducting probable cause hearing? You going to swear to it?
Yes, Your Honor.
Okay. In the matter of People State, Michigan versus Danny Eugene McDowell, charged with count 1, assault with attempted murder, count 2, torture, count 3, criminal sexual conduct, first degree, felony, count 4, unlawful imprisonment, count 5, criminal sexual conduct, third degree, force or coercion, count 6, assault with intent to degree bodily harm less than murder or by strangulation, count 7, domestic violence. Officer, state your name for the record.
Detective Christopher Wilder, Plymouth Township Police Department. Plymouth Township Police Department responded to 12811 Heritage Drive, apartment 203 on 7/13 at 3:58 in the afternoon for a welfare check on a victim. Once they arrived, they contacted the defendant who's in custody, Danny McDowell, and the victim, Faith Allen, at the residence. After speaking with both of them for some time, they were separated. Assault was determined that it happened. McDowell was placed under arrest for domestic. He was transported back to the station. I, as the detective on call, was sent out to the scene, conducted field investigation, conducted interviews. Was found to believe that on Tuesday, a couple of days prior, so it would have been 7/11, assault occurred, including 3 different times where the suspect placed the victim underwater, held her underwater, and at one point on the third assault actually drowned her to the point that she lost consciousness. Once she woke back up, she went to the bedroom.
I'm sorry, all this occurred on the same day?
This was over 3 days, Your Honor.
Over a 3-day period?
Yes, Your Honor.
Okay, go ahead.
So on 7/11, that's when the actual 3 drownings occurred. Third one, she passed out, was no longer conscious when she woke up. She went back to the bedroom. The defendant forced her to perform oral sex on her at that time, or on him at that time. The assault stopped at that point. After he fell asleep the next morning, he slapped her a couple times, which would have been on the 12th. Nothing else occurred on the 12th. We approached to the 13th. The 2 of them had consensual sex at that point on the 13th, after which he threatened to have her fill up the bathtub a second time, to which she was able to reach out to a colleague to call 911, and that's how the police department got involved in the matter.
Okay, what was the torture involved? Was that the strangulation or whatever?
I believe, Your Honor, that's what the prosecutor's office determined to be torture.
Okay. All right. It looks like mental pain or suffering or whatever. All this occurred in the Plymouth, Michigan?
Yes, sir. Plymouth Township.
Plymouth Township. Okay, staying corrected.
Crystal Marie Medina, Your Honor, on behalf of Mr. McDowell, with regard to the arraignment, we would make formal reading and stand mute, Your Honor.
Yes.
Okay, Mr. McDowell, state your name for the record.
Danny McDowell, Danny Eugene McDowell.
Okay, thank you. Mr. McDowell, your attorney hasn't waived the formal reading of the complaint and warrant. The court will enter a not guilty plea in this matter. Argument as to bond, please.
Your Honor, at this time, so we did have the opportunity to speak with Mr. McDowell. I do understand that these are very serious allegations, Your Honor. However, I would ask the court to consider that at this time, they are just that, allegations. Mr. McDowell disputes these allegations, Your Honor. He looks forward to coming to court and addressing the allegations that have been made against him. Mr. McDowell indicates that he is able to stay with his mother at his mother's home on Deacon Street in Detroit, Michigan. He indicates that he understands he's to have no contact with the complainant or with her address, Your Honor. He is 36 years old. He is not currently on probation or parole. While we do see that he has a criminal history, a previous felony conviction, it was back in 2006, Your Honor, and that was for an unarmed robbery, Your Honor. He indicates that he drives for Uber. His monthly income varies, but given his variable monthly income and his expenses, he is not able to post a monetary bond at this time, Your Honor. And so I would ask that the court, he also receives food stamps, Judge. So that means he is under the guidelines. And we would ask that the court consider giving him an opportunity to come to court and address these allegations, Judge. He is a lifelong resident of Michigan, if I didn't mention that already, Your Honor.
All right, thank you. Officer, do you have any comments or thoughts as to bond?
Yes, Your Honor, due to the serious nature of these crimes and the fact that we believe that he's a safety risk to the public, we're asking for a high cash bond, at least $250,000, if not higher. If you do decide to release him, I'd at least ask that he be in a GPS tether, have no contact with the victim, not be allowed to live at the victim's house, not be on any kind of alcohol, drugs, anything like that. So be testing for that kind of thing, and then be in contact with either probation or somebody so that we can kind of monitor what's going on with him. But again, just due to the seriousness of the crimes and our fear for the victim's safety at this point, if he does get released. He did mention during when we were having him process that don't worry, none of the victims are going to come here to testify. So again, we're worried about the safety.
Come on, man. You don't lie like that, man.
Okay.
You don't have no evidence, man.
Sir.
You're just taking her word for it.
Sir.
He just taking her word for it. He don't have no evidence, Your Honor.
Mr.
And I did not say that. I said they're not gonna come because it's
Mr.
not true.
McDowell.
Mr. McDowell, you have the right to remain silent. I would strongly suggest you exercise your right.
Just from that brief outburst he had in the courtroom, you can already see he's doing himself no favors. Yes, technically these are still only allegations, but let's be honest. When you explode like that in front of a judge, it radiates guilty energy whether you are or not. Law enforcement officers don't invent damaging statements on the spot in open court. They know every word is on the record. That alone suggests at least some truth to what's being said about him. Now the judge is floating a $250,000 bond, and that puts him at the start of an uphill climb. Bond isn't designed as a punishment. It's basically a financial leash to ensure you actually appear for future hearings. But when someone stacks up multiple felony charges and has a track record of courtroom meltdowns, no judge is going to take a risk by setting it low. In a way, he's practically handed the court its own argument for keeping him locked up, at least for now. What's wild is how easily he could have avoided it. If he'd simply stayed quiet, shown respect, and kept his head down, he might have had a shot at something more reasonable. Instead, he torpedoed his own chances in under a minute. This is exactly why defense attorneys beg their clients to stay calm. It's not just about politeness, it's about protecting their money, their options, and their freedom. Do you think $250,000 is a fair bond for someone with his history, or should the number have been even higher?
Again, Your Honor, that comment, if made, could have been made for several reasons. One can take it as a negative way, or it could be taken as they lied from the beginning, and so they're not going to come to court and lie under oath, Your Honor.
Exactly.
So I would ask that
Mr. McDowell.
I'm sorry,
Hold
sir.
on,
I'm sorry, sir. This emotional
Hold on,
moment.
Ms. Medina, hold on one second.
I'm
Mr.
sorry,
McDowell,
sir. I'm just emotional right now, man.
it's one thing
I'm
to
sorry.
interrupt
I'm just
me, but
emotional
you're interrupting.
because-
Are you going to be
I'm sorry. Go
quiet?
ahead.
Mr. McDowell,
Yes, sir.
you not only interrupted the court, you interrupted your attorney. And he said she's trying to help you.
I know, sir. It's just, I'm sorry.
Okay. Now, I want you to step aside and be quiet for the remainder of this hearing, okay?
Yes, sir.
Thank you.
Thank you, Your Honor. And so I do think, again, if that comment was made, it could have been made for various reasons, Your Honor. And so I would ask that the court consider that these are verbal allegations that are being made at this time, and that my client has lifelong ties here, and that his previous conviction was back in 2006, Your Honor, and that somehow after 3 days there was access to there's a lot to be flushed through here in the facts, Your Honor. Okay. And so I would ask that my client be given the opportunity to come to court and do just that. He understands he's having no contact with the complainant, and I would ask that the court consider all of that, Your Honor.
All right, thank you, Ms. Medina.
Thank you.
The court, having heard representations of the attorney and the officer on this matter, what is very, very troubling and is indicative that Mr. McDowell cannot control his emotions and impulsive were just demonstrated. And he admitted he's very, very emotional. He responded disrespectfully not only to me, to the court, but to his attorney, and who's acting in his best interest. And so, given his demonstrated impulsiveness, the court's going to adopt a recommendation of the officer: $250,000 cash surety bond, no 10%. If he's able to post that bond, no contact with Faith Allen and no contact with the Heritage Drive apartment located in Plymouth, Michigan. Your probable cause conference date is July 27th, 9 a.m. at 35th District Court. The preliminary examination date is August 3rd, 9 a.m. Just to be clear, and just to clarify the court's ruling, the court deems Mr. McDowell a safety to the community, a safety to the plaintiff witness in this matter, and given his extended emotional outburst before the court just now, the court
If he trying to give me life, why wouldn't I be? Well, he trying to give me life. He don't have no evidence, sir. Why wouldn't I be? He trying to give me life. Man, shut up talking to me, because you trying to give me life, man. And you know it's not true. And he knows it's not true. Why wouldn't I be emotional? He trying to give me life. He ain't got no evidence on none of this. And he's acting for a $250,000 bond. What's wrong with him, man? He don't even got no evidence. Who touched me, man? You ain't even got no evidence. Of course I'll be emotional, man.
Sorry, Your Honor.
He's got me a $250,000 bond with no evidence. Yeah, I'm emotional.
Okay, the court's going to change the bond to $500,000.
Wow, sir, you can change to $500,000. He's still lying. He don't have no evidence. Now it's $500,000. Make it $1 million. It don't matter. I can't post 250,000.
Okay, I'll make it $1 million then.
I can't post none of it anyway.
Okay, sir, step aside. This concludes the hearing.
Okay, Your Honor, so the final amount for the bond?
$1 million.
And is that
Cash surety.
He seen all that shit on her wall, and he ain't taking none of that evidence down, man. I know what he's trying to do, man.
Your Honor, he was put back in his cell. I'm sorry about that, Your Honor.
Okay, no problem. That concludes the hearing. Thank you,
Your Honor.
officer. Okay.
This is exactly what I'm talking about. On paper, he may only have pending charges, but with a prior felony already on his record, the court is never going to view him as a blank slate. Add a public meltdown on top of that, and it's almost inevitable he'll be staring down a huge bond. At that point, you're not just battling the charges themselves, you're also battling the impression you've just left on the judge, and in court impressions can weigh nearly as much as hard evidence. So while $1 million bond sounds extreme at first, think about what the judge is seeing. Someone who appears unable to control himself even in a courtroom. If that's how he acts under direct supervision, what might happen outside on the street? Especially considering the allegations involving violence at home, the court's priority will be protecting victims and preventing intimidation. From that perspective, a high bond becomes a safeguard, not a punishment. In one outburst, he essentially demonstrated to everyone why he can't yet be trusted. If the accusations prove true, a long prison term would be deserved. But even before trial, his own conduct is shaping the outcome. Do you think the judge's bond decision was fair, or did it cross the line?